Mr. Mays, good morning. Are you ready to go with your client?
I am.
Is your client here?
No, my client is not here
Why is that?
because I told her yesterday that as I filed an appearance, I would contact the court and try to get this moved to a new date.
The court is the one that can tell your client not to appear, not anybody else.
I had no reason to believe that this court would decline to enter that stipend order, and I don't quite understand why the court did decline to enter that order.
Because counsel, the information I had was that you submitted that this morning.
Yeah.
And that you, right before submitting that, you submitted your appearance. You filed your appearance just 3 minutes before submitting your request for an adjournment.
That's not true. I had told my client, hey, I submitted a stipend order for the court to enter so we can get us a new date. Now, just to be clear, so that I don't look like a lunatic in front of the public here. When a stipend order is provided to a court, almost every judge in my experience ever enters the order. There is absolutely no reason why we couldn't have appeared by Zoom this morning if the court really felt that it was necessary for us to address, say, a bond issue for arraignment purposes. Personal appearances should not be the norm because as pointed out.
Counsel, we're done. This court indicated that it set its dockets on Tuesdays, Wednesdays, and Thursdays in person. That is what this court did. Yes, the court rules allow for teleconferencing, Zoom, otherwise. Hybrid dockets, whatever it may be. When this court receives communication less than half an hour before the case is scheduled to appear, the court is not inclined to grant that stipulation and that request. I will allow you to have your client here tomorrow morning with your other client, if that's who your other client is, Mr. Alfred Dalton, at 9:30 a.m.
Yes, we're all ready to go.
Wait for, all right, as soon as Mr. Westmoreland jumps in here, we will handle that. In the meantime, going on the record in the matter of the state of Michigan versus Alfred Dalton Jr., 231720.
Good morning, Your Honor. William Mays on behalf of Mr. Dalton.
Good morning, and sir, your name for the record, please.
Alfred Henry Dalton Jr.
Okay, thank you. And today is the date scheduled for
Take
the
your hat off.
arraignment in this matter. And counsel, as to the arraignment.
We would waive reading, ask the court to enter a not guilty plea.
Francisco Galvin.
Okay,
Sentencing.
and sir, or counsel, you submitted your appearance today?
Yes.
Okay. And Mr. Dalton, you understand you do have the right to have an attorney, and if you cannot afford to retain your own attorney, the court will quite want to represent you.
Yes, Your Honor.
Okay. And in fact, you've availed yourself of your right to an attorney and you retained your own counsel, correct?
Yes, Your Honor.
Okay. You also understand that you have the right to be presumed innocent to prove guilty beyond a reasonable doubt.
Yes.
Understand you have the right to a trial by a judge or by a jury.
Yes.
You also understand that you have the right to remain silent. Anything you say orally or in writing may be used against you in court. Do you understand those rights?
Yes.
Okay. And the court will enter the not guilty on your behalf. And I'm sorry, counsel, you already conducted the PC with Mr. Shajra?
Yes, and we are prepared to hold preliminary examination either a week from today or if necessary, October 19th. In which case, if you had to take it out to October 19th, I've advised Mr. Dalton his right to a prompt preliminary examination, and he will waive that requirement if it's necessary. Otherwise, we're ready to go next week.
Okay, well, next week we'll have to be at the 28th District Court. That would be on Friday, the 25th. This court doesn't have a docket next Thursday.
Well, that changes possibly everything, so let's hold on. So no docket on Thursday next week. What time do you want to hold it on the 25th?
Well, it would be in front of Judge Mullins. I will be at a conference,
Okay,
so I'll be at the 28th District Court.
I see. If I could call Judge Mullins maybe, because I can do it, it's just that it's got to be a little bit later in the morning.
Well, Judge Mullins isn't available to talk right now, but there's generally scheduled at 9 a.m. and how she pulls them, I don't know. She handles her docket that way, so I can set it for 10:30.
Or we can waive out to October 19th.
Why October 19th? You can't do anything in September,
I
Council?
have no Thursdays available aside from the 24th. And the prosecutor indicated it has to be a Thursday.
Right, there's not a 24th on a Thursday. There's not a Thursday, October 20, there's not Thursday, the 24th at all. Is Thursday, the 14th available?
A week from today is the 24th.
Oh, I'm sorry, I thought, okay, okay. Well, that's not available for the court, it would be on the 25th. I can't go all the way out to the 19th for an exam. That's a significant time period, so I can do it for the 25th at 10:30 a.m. next Friday.
I probably won't be able to make it by 10:30, that's the problem. Yep.
Okay, for what time? What time is your candidate?
9 a.m. for Canton.
11 a.m.?
Yeah, maybe, hopefully. But that's all right, I get along with Judge Mullins all right, so she might have a little flexibility with me.
August 25th at 11 a.m. at the 28th District Court. And as to bond counsel,
I would ask for personal recognizance. This is a low level felony. Doesn't have any prior controlled substance violations on the record. And we have every reason to believe that it's going to be dismissed at the preliminary examination based upon some things that I've reviewed in the police report today. So I can go through the factors under 6.106D if you need me to, but I don't think that there's any reason for anything other than a personal recognizance bond, and no allegations that would cause me concern would rise above the idea that it should just be personal recognizance without conditions and without any sort of monitoring or anything like that.
and Mr. Dalton, you reside locally,
Yes.
and where do you work?
Right now, this case has caused me to, I lost my job. Since the two days I was here. So right now I'm unemployed. But I've been looking for jobs. I got a couple opportunities right now.
All right, and,
But I haven't worked since the day I was arrested.
okay, where were you working?
Carmuse lime and stone. Out in River Rouge, it's like a limestone refinery.
Okay, and sir, you have a couple warrants out for your arrest.
Yes, I was just aware that today. I'm gonna take care of those by the end of the day.
Why didn't you appear in court? on
They
those
did not
matters?
notify him of those. I think it's just outstanding fines.
That's what I was.
But I'm confused, they didn't notify him, or he, took care of it, but didn't pay the fines and
It
costs?
was, I've been provided no information aside from what's in the police report, where the officers indicated that there were these 2 warrants out for him. They didn't even tell him that that was the reason for the traffic stop. So this is the first we've heard of it, and I talked to my client about it, and think that it's just an unpaid fine.
Okay, well,
We have no further information on that.
I'm going to give it to you right now. There's one out of the 25th District Court for a matter out of E-course. It says it's a civil infraction, local ordinance. The date of that warrant was March of 2022. Then the other warrant is out of Taylor. The date of that warrant was February of 23. And that indicates that it's also for a civil infraction, local ordinance. Both of these are for FTAs on those. So, sir, make sure you're taking care of those. At least at a minimum, contact the court to find out what it is you need to do. I can tell you the Lincoln Park matter, the 25th District Court, it indicates $350 cash or surety bond. And then the 23rd District Court indicates $400 cash bond. Presumably that's the cost of the tickets, I don't know.
Yeah, we'll get that paid right away.
And sir, other than those two matters, have you ever failed to appear for court?
No,
And are you prescribed any medication?
no.
And so if you were to test today, sir, what would be detected in your system?
Judge, I'm gonna instruct my client not to answer that question. And exercise his fifth amendment privilege to remain silent.
Sir, I'm not intending to log additional charges against your
I
client.
understand. I don't want him to answer that question.
Okay. In the event anything illegal would be in your system, sir, I'm going to indicate that you're not to possess or consume any alcohol or drugs unless prescribed. And you've indicated you don't have any prescription medication, so there shouldn't be anything in your system moving forward. If there would be anything in your system today. The court's going to indicate a $10,000 personal bond. You've appeared here today. The court's going to indicate you're not to possess or consume any alcohol or drugs unless prescribed. The court's going to also indicate, sir, you're to clear up your warrants or make it, at least start the process of clearing up your warrants. So make sure you're complying with the court's orders of bond. You don't know when you're gonna get called in for testing. All right? Have a good day.
Thank you, Your Honor.
And just don't forget, next week is at the 28th District Court in Southgate. All right, and this is the matter of the city of Riverview versus Emily Kuzno, 231483.
Good morning, Your Honor. William Mays on behalf of Ms. Kuzno. Okay. State your name for the record, please.
Emily Kuzno.
And Your Honor, we're here for an adjourned arraignment, I guess?
Arraignment pretrial, yes.
Okay, so I did meet and discuss the case with the prosecutor yesterday, and I told him that we were actively out of the courtroom yesterday morning. I indicated to the prosecutor, hey, we're set for a pretrial arraignment tomorrow. Can you get me the discovery by tomorrow? And he said no. So he is unable to get me the discovery in this short, brief time period. I'll let it slide this one time, Judge. But I would ask that you set this matter as quickly as possible because my calendar is going to be a mess here in just a few weeks. Maybe
Well, first, let's do the arraignment.
waive reading and ask the court to enter now.
Ma'am, your name for the record, please.
Emily Kuzno.
All right, the court's going to waive the formal reading, enter a plea of not guilty for purposes of the arraignment. And then the court is going to schedule this matter for a pretrial. Mr. Dox and Mr. Artress, you can please join for breakout room 3. We can set this for pretrial on August 30th, counsel. It has to be a Wednesday, that's a Riverview day.
Has to be Wednesday. Just a second, Judge, please. I can make the 30th work. But what time?
Well, counsel, what works for you?
A little bit later in the morning would help. Let's say 10:30.
August 30th at 10:30 a.m. And as to, your client did post the bond, counsel.
She did, and there's nothing about this case that, or her background for that matter. I've been able to take a look at her background. It's extremely clean. And this is a low-level first offense with nothing, no accident, no outrageous or high alleged BAC in this case. So I would ask for personal recognizance without conditions.
Ma'am, do you work?
Yes, I do.
And where do you work?
I work at Brewery Terrace, it's a nursing home.
Okay,
Physical
And-
therapist.
okay. And you still reside at the address on file in Riverview, correct?
Yes,
Have you ever failed to appear in court for any reason? Are you currently on probation or go anywhere? Mr. Dox and Mr. Otrust, please join
Hi.
the breakout room.
Can you,
I'm on the record in another matter, so I can't have anybody address the court. And then, when's the last time you consumed alcohol?
last weekend.
The court will continue your cash bond. You're not to possess, consume any alcohol or drugs, ma'am, that are not prescribed. Do you have any prescription medications? Okay, so no alcohol or drugs unless prescribed. Especially given the fact the allegations in this matter, and the court wants to make sure, ma'am, that the public as well as yourself are safe from that behavior. And then we will see you back on August 30th at 10:30 a.m.
Thank you very much, Your Honor. Have a great day.
You as well. The discovery counsel, you got a copy of your discovery order?
I did.
The court will note the discovery order was signed.
Thank you.